The Karnataka High Court today, while allowing a petition filed by a minor boy, set aside the investigation initiated against him under various provisions of the Protection of Children from Sexual Offences Act, that is the POCSO Act, for allegedly sexually assaulting a minor girl following a mutual settlement having arrived at between the parties. Justice M Nagaprasanna, while pronouncing its order in open court today, said, and I quote, "Petition is allowed, proceedings against the petitioner stands terminated." Earlier, the High Court had directed that further investigation in the matter shall remain stayed, subject to the result of further orders being passed. In this particular case, the petitioner and the complainant's daughter are minors even till date and were in a relationship which resulted in the present crime being registered. Today, the counsels appearing on behalf of the petitioners apprised the High Court that parties have settled the issue and have sought termination of the proceedings on account of such a settlement. Reliance was placed by the petitioner on the judgment of the Madras High Court in the case of Vijay Lakshmi vs. State, wherein the Madras High Court had quashed the POCSO case on the ground that the intention of the POCSO Act is not to punish a teenage boy who is in a relationship with a teenage girl. It was also argued on behalf of the petitioner today that when the complainants themselves do not wish to prosecute the case, then continuing the criminal proceedings is only going to be a miscarriage of justice. On the other hand, the prosecution had objected to this on the ground that since the offence has been registered under the POCSO Act, which is a penal legislation, thus a mutual settlement cannot be accepted at this stage. Importantly, the Supreme Court has recently observed that it has faced certain difficulties while considering the applicability of the POCSO Act in cases where teenage girls slightly below 18 years enter into physical intimacy with another adult. A bench headed by Justice Indira Banerjee had observed that there are serious difficulties because of the definition of child under the POCSO Act. For those of you who are unaware, Section 2 subsection D of the POCSO Act defines a child as any person under the 18 years of age. Adding to this, Justice M Sundaresh, who was also a part of the Supreme Court bench, gave another example by stating that in some tribal areas, girls get married by 15-16 years of age, and that when they come to hospitals for delivery, their counterparts are also booked under the POCSO Act. As the hearing progressed, the Supreme Court bench had further observed that parents of the children generally file cases against males under the POCSO Act. The Supreme Court bench had also orally remarked how it is important to protect the woman's interest and that the problem arises when the complaint is not filed by the alleged victim girl but instead by the parents or other relatives. Let us know what your opinion is on this particular issue in the comments below. We would love to know. Thank you. This is Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.